Great. Okay, welcome back, committee. We are going to wrap up our legislative day on looking at advanced directives, Ulysses Clause, and what current statute is, what we have in place for temporary provisions, COVID era provisions, and where we might be going in the future. So, Ms. Carby, would you join us at the witness chair? Legislative Council is going to give us an overview and kind of acquaint us with this whole area, because it might be new for some people, and for the rest of us, it is definitely a good refresher.
Great.
Welcome.
Thank you. Jen Carby, Legislative Council. So I will.
Pages.
Sorry, we're just chuckling because one of the pages came in and saw the person that he was looking for wasn't here, and he went, and out the door he went.
New pages.
Yeah.
We gotta go back to that room.
Okay, great.
All right. Let's do this for a second so I can put it in the slideshow mode. There we go. Okay, so as the chair said, we will be going over advanced directives. I wanted to give you an overview of the existing statute, talk about some COVID era provisions, and discuss a little bit about those often referred to as Ulysses clauses. So let's go through here. So first thing is, what is an advanced directive? An advanced directive is a written document in which an adult with capacity, who is called the principal, can do a number of things. They can appoint an agent to make, so the main things are, they can appoint an agent to make healthcare decisions for them if they're not able to make their own healthcare decisions. They can express the types of healthcare that they do or do not want to receive, including things like when they want to be transferred from home, things dealing with hospitalization, what they do or do not want in the way of life-sustaining treatments, et cetera. They can specify the circumstances under which the agent under their advanced directives authority becomes effective. They can identify some preferred clinicians. They can make or refuse to make an anatomical gift, that's an organ donation or a donation of other body or tissue part, and they can direct disposition of their remains. The advanced directive combines what was formerly known as a healthcare power of attorney. That's the part about appointing an agent to make decisions for you if you can't make your own, and a living will, which is where people express their end of life kind of healthcare and disposition wishes. There is an option to file an advanced directive with the Vermont Advanced Directive Registry, which makes it accessible by hospitals and other providers. And I've just put the link in here through the health department. So we're going to go into a lot more about these provisions, but that's the big overview.
Jen, can I ask a quick question there? So do you know if there are any, I don't know, rules, guidelines, some sort of instruction for healthcare providers to check this register?
We'll get to some of that, but yes, there are requirements that they check if somebody comes in without capacity, and they're supposed to have protocols in place for when and under what circumstances and who checks.
I'm just like,
It's mandatory, yeah.
yeah, I mean, I reference personal experience, you know, that didn't happen with
Doesn't
my
mean
mother.
it happens, right?
Right,
The
yeah.
fact that it's mandatory.
She has an advanced directive. You know, and then they went off and checked her advanced directive, but, okay.
All right, so, and as I said at the outset, an adult with capacity, which is defined, may execute an advance directive at any time. And there's a whole list in 18 VSA section 9702 about the items that may be included in an advance directive. Those are some of the things that were on the previous slide about appointing an agent and expressing specific wishes regarding care, but there are a lot of other categories that can be of types of things that people can put in an advance directive. They're not all, none of them is required, but there are certain things that do have to be in an advance directive. And those are what's listed under the must requirements. So the date, the advance directive must include the date. It must be signed by the principal or by another person in the principal's presence at the principal's express direction if the principal is physically unable to sign. and it must be witnessed. The principal must sign the advance directive in the presence of 2 or more witnesses who are at least 18 years of age, who have to sign and affirm by their signature that the principal appeared to understand the nature of the document that they were signing, what an advance directive is, and to be free from duress or undue influence at the time the advance directive was signed. The statute provides that a healthcare provider can be a witness, so a healthcare provider may serve as a witness, but an agent who is being appointed by an advance directive, a principal's spouse, parent, adult sibling, adult child, or adult grandchild cannot serve as a witness.
And I'm presuming the rationale for those are people who could be financially impacted or impacted in some material way by witnessing.
Potentially, it's also if they're being named as the agent to make the decisions, it's difficult, maybe more difficult to determine that the principal was free from duress if the person who they're appointing to make their decision is one of the witnesses.
To the agent. Okay. Yeah. Okay.
There are some additional explanation requirements if a principal is being admitted to or is a resident of a nursing home or residential care facility or is being admitted to or is a patient in a hospital when they are executing their advance directive. In that case, in addition to the witnesses requirement, there's an additional requirement for someone to explain the nature and effect of the advance directive. And my understanding of the rationale there is just that it may be a more fraught time for the principal, and they may be more susceptible to coercion. So for nursing homes and residential care facilities, what we sometimes refer to by way of shorthand as the explainer must be, and there's a list of eligible individuals to be the explainer: an ombudsman, recognized member of the clergy, a Vermont licensed attorney, individual designated by the probate division of the Superior Court, someone who is designated, a hospital designated explainer, so they can also serve as an explainer in a nursing home or long-term care facility, a mental health patient representative, a specially trained nursing home or residential care facility volunteer, or a clinician who is not employed by the nursing home or residential care facility. And it's a shorter list for hospitals. The explainer there must be an ombudsman, recognized member of the clergy, Vermont licensed attorney, probate division designee, hospital designated explainer, or mental health patient representative. And there are some additional provisions around these and around the training that's in the statute. And then I've included, it's a long chapter, so I've included some additional provisions just to kind of give you a sense for how the whole process works, but there is a lot more detail to be found in the chapter itself. So there's provisions around amending, suspending, and revoking an advance directive. So amending obviously is changing it, suspending it means having it not in effect, and revoking it means having it permanently not in effect. So a principal with capacity, somebody who is able to make decisions, may amend, suspend, or revoke all or part of their advance directive. A principal without capacity may suspend or revoke all or part of their advance directive. They cannot amend it. And this will come up, this idea of capacity or without capacity will come up again when we talk about the Ulysses Clause later on. And in most cases, filing for divorce, annulment, dissolution of a civil marriage, legal separation, or a relief from abuse order suspends a previous designation of the spouse or opposing party as the agent. So people don't have to worry if they have filed for divorce, but it isn't final yet, that their soon-to-be ex will be still able to make their healthcare decisions. Under 18 VSA 9705, there is a duty to deliver an advance directive. So anyone in possession of a duly executed advance directive has a duty to deliver it to the principal's healthcare providers if it seems that the terms of the advance directive may apply. So if you have one for somebody, if you have possession of one for somebody, and it may be applicable, and you don't know if the provider has it, you may have a duty to deliver that.
So does that duty to deliver include, so if somebody, say, works with an attorney to do an advance directive, does that duty to deliver apply to legal counsel as well, or do they have to do so only at the request of the individual?
I'm pulling up the statute just so that I can speak more. The extent of the statute is an individual possessing a duly executed advance directive to whom it becomes known that the terms of the advance directive may be applicable shall deliver the advance directive to the principal's clinician, other healthcare provider, healthcare facility, or residential care facility unless the individual knows that another copy has been previously delivered and is available. So if the attorney doesn't have a reason to know that the terms may be applicable because they're not in, frequent communication, then it doesn't sound like there would be a duty to deliver in that instance. All right, get back to. Attempt to resume my slideshow. Slideshow, there we go. All right. Make sure I didn't go too far. I did go too far. All right, where are we here?
I think where
No,
it becomes
back.
effective.
I know,
Yeah.
it's having a mind of its own. Hold on a second.
Selected other, page 6 of 15.
I'm I'm picking a page and it's picking a different one. All right, now it's at least letting me use the button.
I think you're doing a great job.
Okay,
So alert of everything that's going on.
I was wondering, who is that guy sitting next to
To
me?
me, that low voice.
Nobody knows.
try again here with, or we'll just start. All right.
There we go.
So when does an advance directive become effective? It depends typically on what's in the advance directive. So it can become effective when the principal's clinician determines that the principal lacks capacity, or when a circumstance or condition that's specified in the advance directive has been met, or upon execution when it's signed, if that's what was specified in the advance directive. So the principal kind of gets to decide, is this effective immediately? Is it effective only if I lose capacity? Is it effective if some other circumstance is met? And then an agent's authority to make healthcare decisions under the advance directive can cease to become effective. So if it was effective only when the principal didn't have capacity, then if the principal regains capacity, the agent's power goes away until the principal loses capacity again. Or if the circumstance or condition specified in the advance directive is no longer met. Also, if the principal suspends or revokes the advance directive itself or the designation of that agent's authority to make decisions would go away. Here are the authority and obligations of healthcare providers and facilities. So this is the part I was mentioning earlier. Healthcare provider or facility is prohibited from providing healthcare to a patient who doesn't have capacity, except in an emergency, without first attempting to determine whether the patient has an advance directive in effect. And if there is an advance directive in effect, the provider or facility must follow the agent's instructions in most cases. And in the other cases can be if the advance directive says something inconsistent with what the agent is saying, or what the agent is saying to do is against the law or outside of the provider's scope of practice. But for the most part, they have to follow the agent's instructions. And the healthcare providers and facilities are required by the law to develop protocols regarding advance directives, including asking patients whether they have an advance directive, updating and maintaining their advance directive records, and checking the advance directive registry. And I will just note that most of these provisions have been in effect in some form since 2005, which is when this joining together of the healthcare power of attorney and the living will into the advance directive came into Vermont law. All right, some other provisions. Authority of the agent. When an advance directive is in effect, the agent has the authority to make any healthcare decisions for the principal that the principal could make if the principal had capacity. If the principal has capacity, and the agent has authority at the same time, then the principal and the agent have concurrent authority. But if they disagree, then the principal's decision is controlling. There are specific decision-making criteria in the statute for the agent. The agent must make healthcare decisions for the principal by first attempting to determine what the principal would have wanted under the circumstances. And if that's not possible, then the agent makes the determination based on an assessment of the principal's best interest. But the first line of action is to try to determine what the principal would have wanted under the circumstances. And then there's some specific provisions saying the agent cannot authorize providing or withholding health care based on the principal's economic status or based on the principal's pre-existing long-term mental or physical disability. The agent also cannot make decisions based on the agent's own interests, wishes, values, or beliefs. So the agent can't say, well, I think the principal would have wanted this, but I think this is a better choice. They have to determine what the principal would have wanted under the circumstances. The agent has the right to a significant amount of the principal's medical information. So unless it's specified otherwise in the advance directive, the agent really has the same rights as the principal to request, review, receive, and copy information about the principal's health, to participate in meetings, discussions, and conferences about the principal's health care, to consent to the disclosure of healthcare information, and to file a complaint on the principal's behalf regarding a healthcare provider or facility. There is immunity for good faith actions under the advance directive statutes. So there's no civil or criminal liability for an agent who makes a decision in good faith pursuant to the terms of an advance directive. And there's also no civil or criminal liability for a healthcare provider or facility for providing or withholding treatment or services in good faith pursuant to the direction of the principal or patient, the provisions of the advance directive, or the consent of the principal, patient, or agent. There are, however, some penalties for failing to follow an advance directive. Providers can be subject to disciplinary action by their licensing authority if they fail to follow an advance directive or for accessing the registry without authorization. And there's a reciprocity provision that basically recognizes that there may be similar documents executed in other states under those states' laws, and our advance directive statute does not limit the enforceability of an advance directive that was executed in another state in accordance with those states' laws. So that's a general overview of advance directives. Maybe I'll pause there.
Does not limit enforceability executed in other states. Okay, so will you explain a little bit more like what that means, that last sentence, that last bullet?
Yeah, so if there's an advance directive or a similar end of life and healthcare power of attorney document executed in another state that doesn't line up with exactly how advance directives would be required to be drafted in Vermont, they're still valid and need to be followed by Vermont providers as though they were validly executed here because they were validly executed in
that other state.
Okay. Right. So people who move into this state with an out-of-state advance directive don't have to do a new advance directive just because they moved to Vermont.
Okay.
That was my question.
And is that reverse?
To the extent we can, I mean, hopefully.
Yeah.
That's sort of a full faith and credit kind of thing. If it's validly executed in our state, it should be recognized in other states.
Yeah, go ahead, Representative Brumsted.
So there's nothing though in the current law that we're going over right now that would say that you fill out, this weekend, I fill out an advance directive and I do all the right pieces. Everyone knows and it's been filed. But then, and I think it's for when I get much older and I'm on my way home and I'm in a car accident and I'm worried that they might, when I come into the hospital, I'm still with it and I can say, I have an advance directive, but I don't want you to look at it. Can I do that then? Because I'm worried that I'm too young to die or something like that.
Well, if you're able to make your own decisions, whether or not you have an advance directive, they should be talking to you about and getting consent from you about what you want done in the moment. Okay. So really the wishes that you're putting for your treatment and the authority that you're giving to your agent are if you can't make your own decisions, you're not able to communicate your own decisions. So if you are with it enough to say, I have an advance directive, then they shouldn't be relying on the advance directive. They should be relying on you.
Okay. I looked ahead, so.
Okay.
Okay.
So next we will look at some, what I called kind of the COVID era provisions. These have to do specifically with remote witnessing. So the section of statute 18 VSA section 9721 was first enacted and took effect on June 15th of 2020. So you remember where we were in the pandemic at that point, still pretty early. And was most recently extended through March 31st, 2024. It was on the House floor a few weeks ago and has been signed by the governor and is now Act 4. And what those provisions said is, first we had kind of a looking backward. So this was being worked on in roughly May to June of 2020. Looking backward to the early days of the pandemic and kind of deeming valid advance directives that were executed between February 15th and June 15th of 2020, saying those were okay even if the principal signed those outside the physical presence of witnesses, because people were trying very hard to stay away from other people, if certain conditions were met. The principal and the remote witness were known to each other. The remote witness was informed about the role of a witness to an advance directive. What is this thing that I'm witnessing? And the principal included the witness's name and contact information. So those conditions were met, and the advance directive was signed outside the physical presence of one or both of the witnesses. That was okay for a limited time. Those advance directives were valid for about up to a year. So until June 30th, 2021, and then somebody needed to do a new advance directive. So then there was an intermediate step. That's where we are now. Advance directives executed between June 15th, 2020 and now March 31st of 2024 will be deemed valid even if the principal signed outside the physical presence of one or both witnesses. If, again, the principal and remote witness were known to each other. This specifies, based on video or phone communication, the remote witness attested that the principal seemed to understand the nature of the document and to be free from duress or undue influence. Remember from the beginning, that's one of our regular in-person witnessing requirements. And the principal included not only the witness's name and contact information, but also the nature of the relationship between the principal and the witness. And these advance directives will remain valid indefinitely unless and until they are amended, revoked, or suspended. And then in addition, for this whole period, from the beginning of that, February 15th, 2020 through March 31st, 2024, if an advance directive was executed while a principal was in or being admitted to a hospital or long-term care facility, those are deemed valid even if the explainer was not physically present for the explanation, as long as they were communicating with the principal by video or telephone. So this is where we currently are as far as remote witnessing. We have some temporary remote witnessing provisions. I'll come back to this a little bit at the end. All right, now we're getting into Ulysses clauses.
Take a deep breath.
So worrying.
My use of art and literature. All right.
When you read that, it's like.
So for those of you who remember your Homer, in the Odyssey, Odysseus, and in English Ulysses, wanted to hear the siren song, and so he plugged his men's ears with beeswax and said, "Tie me to the mast." And he wanted to listen to the siren song without being carried away, letting his ship be dashed upon the rocks. And so he said, "Tie me to this crosspiece halfway up the mast, and with a bond so tight that I can't possibly get away. But if I beg and pray for you to set me free, then bind me more tightly still. So do not let me go, no matter what I say. Even if I change my mind, this is what I want, and this is and please enforce that." So we have a Ulysses clause provision. It's not called that in the statute, but it is the shorthand way we have long referred to this provision. So this specific provision of statute, 18 VSA 9707 subsection H, allows an advance directive to contain a provision permitting the agent, if the principal lacks capacity the agent can authorize or withhold healthcare over the principal's objection. So this is the Ulysses, I'm saying now what I want, hold me to it, even if I later change my mind. In order to be valid, there are additional provisions that have to be in a Ulysses clause. It has to name the agent. So there has to be a specific agent named here who can authorize or withhold care over the principal's objection. The agent must accept this responsibility in writing. The principal's clinician must sign the provision and affirm that the principal appeared to understand the benefits, risks, and alternatives to the healthcare being authorized or rejected by the principal in that provision. So whatever healthcare it says the agent can authorize or withhold over the principal's objection, the clinician needs to affirm that the principal seemed to understand what they were doing. An ombudsman, mental health patient representative, licensed attorney, or probate division designee must sign a statement affirming that they explained the nature and effect of this provision to the principal, that the principal appeared to understand the explanation, and that the principal appeared to be free from duress or undue influence. The provision must specify the treatments to which it applies, and it must include an explicit statement that the principal desires or does not desire the proposed treatments, even over the principal's objection at the time the treatment is being offered or withheld. The provision must include an acknowledgement that the principal is knowingly and voluntarily waiving the right to refuse or receive treatment at a time of incapacity, and that the principal understands that a clinician will determine capacity. The provision takes effect when the principal's clinician and a second clinician determine that the principal lacks capacity. And if an advance directive contains one of these clauses, then the agent may, as we've set up, if the principal lacks capacity, make decisions over the principal's objection, provided the decisions are based on what the principal would have wanted under the circumstances. And the clinicians must follow those instructions of the agent authorizing or withholding healthcare over the principal's objection. Pause here for a moment.
Yeah, I was going to say, so we have somewhat of an expert on our committee around this clause.
Well, and I will just acknowledge the Representative Donahue, I think, was in this committee when this whole chapter and this provision were originally enacted. It was shortly before I came here, so she has the best historical information.
And I didn't remember that you weren't here yet for this, but yes, it
2 years
was,
before me.
it was a very, very lengthy bill and project that we worked on. It was a big piece. And the Ulysses Clause was a very specific sub-discussion. It was actually something I was strongly advocating for, but also there were a lot of fears, concerns about the amount of authority somebody was delegating, and therefore the agreement to put it in was really premised on all of these extra protections to make sure this person really understands and really wants that, because they're creating this, they're tying themselves in. So, and it can be used for, some states have this separate thing called the Psychiatric Advance Directive, which actually in some ways gives you less power than if you had a regular one. And Vermont's always had one that applies to anyone. My interest in this had a lot to do with people with psychiatric conditions, but it equally applies for any other reason. But anyway.
Yeah, I mean, I'm just relating to your Older Vermonters caucus at noontime of people with dementia, people with Alzheimer's, and
that's another really good example, because if somebody knows what they want, then they could have dementia down the line and be saying, no, don't do this. And when in fact they want it done, and they would have wanted it done. And this enables them to ensure that what they actually wanted when they were themselves does happen. But it locks you in, so it's a big deal.
Yeah, it is a big
I
deal.
think it's kind of scary
It's
that you lose your ability to say, no, I changed my mind now that I'm here. A lot of people feel differently when they're truly faced with death.
Well, but if you have capacity, you can change your
You can
mind.
change it.
Revoke it. It's only if you no longer have
Determines that
capacity.
You have capacity.
Two
doctors.
Two physicians.
Two for this rather than just one.
So John wants to get rid of you.
Yeah.
But
I saw Representative Whitman on the screen.
Yes, okay, go ahead, Representative Whitman. Thank you. Thank you, Jen.
Yeah, thank you, Madam Chair, and thank you for the presentation. Yeah, I guess I just wanted to ask clarifying, because we keep saying you're locked in if you sign the Ulysses clause, but at any point, if you are determined to still have capacity, you can change that after you initially make the decision to, put in the Ulysses clause. And I guess I just had more questions, and sorry if you covered this, but just how is that determination made again? You said it's two physicians to determine that you either do have capacity or don't have capacity at a given
Right.
time.
Two physicians determine that the principal does not have capacity before an Ulysses clause would kick in. And there is, under the definitions at the beginning of the chapter, capacity means an individual's ability to make and communicate a decision regarding the issue that needs to be decided. And then it goes on to say, an individual shall be deemed to have capacity to appoint an agent if the individual has a basic understanding of what it means to have another individual make healthcare decisions for oneself and of who would be an appropriate individual to make those decisions and can identify whom the individual wants to make healthcare decisions for the individual. And then an individual shall be deemed to have capacity to make a healthcare decision if the individual has a basic understanding of the diagnosed condition and the benefits, risks, and alternatives to the proposed healthcare.
I think that's actually a fairly unusual definition of capacity that recognizes that there are different levels of capacity. And it's basically saying you might not have the capacity to make a full decision about a healthcare decision, but you know enough to identify who you want to make decisions for you. And then you have the capacity to make that in an advance directive to appoint someone, even if you don't have full capacity to, to choose a specific
You
treatment.
can see the definition.
Go ahead, James.
I got a question. So Jessica's scaring the daylights out of me over here. So what if, a doctor, I guess, would have to, but what if you're a person and you're in a situation where you may come in and out of times where you're, because if say you have some kind, well, that's what I was thinking.
Yeah.
So, I guess at that point, I don't know. But you made me think of something, Jessica, and I don't like that you're confusing my brain today. But what do you do in that situation? Like maybe you make something of a sound judgment, and then by the time the doctors get there, you're back into your, I don't know how this stuff works, but now you get real paranoid about this. It's a concern. I'm being serious.
I am.
Joking
I
at
know.
the same time.
Well, it seems as though the doctors are making an assessment at the time that they're seeing you, right at that moment, that they're seeing you. And so, yeah, it's not something to be entered into lightly. So it's one of those things that part of why I wanted Jen to give us an overview of this in particular is because there's proposal to allow this.
A couple more, yes, we have.
Yes, we have more. Okay, keep going.
I certainly believe in it. We've been over this over the years. I have one. But
Ulysses clause?
No,
I have one.
advanced directive. Yeah, I won't be Ann and ask everybody, because I can't raise my hand. Not this hand.
No, I know.
The other hand, yes.
Do you have yours?
You have yours?
All right,
Question we always got.
so two more slides. One of them is there is a bill on your wall, a short form, H469, introduced by the chair, I think to get the conversation started. And this short form bill would allow remote signatures, affirmations, and explanations for a Ulysses clause. So for a provision that the principal may choose to include in an advance directive, allowing the principal's appointed agent to authorize or withhold healthcare over the principal's objection. So that's a narrower one, and then there's some broader issues.
I have a question about that, because when I went back and read the Ulysses clause provisions, I realized none of it actually says in current statute that it must be done in person.
A lot of the language is in the presence of, so we have been explicit in 47, no, whatever it is, the COVID era ones, we have been explicit that it doesn't have to be in the physical presence.
I understand, but when I looked at the Ulysses
Clause
one,
specifically,
I don't believe it says in the presence of.
it made.
I think implicitly you.
Right, I think
the assumption at the
implicitly,
time was that it was in.
and in the context of the physical requirements for the rest of
For
the,
the rest of the, yeah.
I mean, yes, I think you can make an argument, but it's a bit open. And then that kind of brings up the broader policy question of whether the remote provisions, the remote COVID era provisions that are currently in effect, the remote witnessing provisions that are currently in effect through March 31st, 2024, should be made permanent. And this came up because some advocates, particularly down the hall when they were working on the COVID flexibility bill, had recommended allowing the remote processes for advanced directives to remain an option indefinitely, including remote witnesses for the advanced directives, remote explainers, remote witnesses and explainers for Ulysses clauses, and then potentially electronic signatures for any and all signatories to the advanced directive. So that's really the issue that I am also teeing up for potential discussion, is the future of remote witnessing. Any questions?
More questions, yeah.
I'm going to ask the question that our chair asks, which is, what is the problem? Why do the Ulysses? We have advanced directives.
Well, we don't have it permanently. We don't have COVID era flexibility.
No, but
permanently.
I'm going back to the original bill, just about, should we have a Ulysses clause? I definitely.
Clauses are in existing law.
Oh, we already
It already
have
exists.
this. Wow.
Yes, it's really a question of
Okay.
whether you.
Definitely don't want
You don't need to
Ulysses
do one.
remote. No.
Question is,
That's
can it be
the
done
issue.
remotely?
Be done remotely, that's the
That's the
question.
question.
I like.
Nobody has to do them.
Extend advanced directive remotely, just in general, but the Ulysses, to me, you need more. I don't know. That's scary. What if someone's out to get you? I don't know.
I think that
Maybe I've watched too many.
That's okay. We're having discussion.
I've done a deep dive into it, and I've had extensive conversations with Ann. The amount of protections and the amount of things that have to happen for you to create one, to have one trigger, and to have one be co-opted for some nefarious purpose. The so many things that would have to happen that the likelihood is so small, and the benefits from everything I've been reading. I mean, I know ours is more restrictive, and we don't have the Ulysses clause, psychiatric Ulysses clause, but the literature and the Virginia law that I've read is the benefit really does outweigh, especially if you have pre-existing psych issue, where you know actually that you will become incapacitated most likely at some point in the future. It may be a month, maybe a year, maybe 2 years. Right now you're perfectly treated, but you have a condition and the possibility is almost 100% that it will come back at some point.
So I hate to open up a kettle of worms on this, but so does this apply to people who receive medication for mental illness and then they decide for whatever reason to stop taking the medication and they've implemented this, and so then somebody can say.
And that's in fact gone to the Vermont Supreme Court. There have been decisions. Yes, you can use an advanced directive to say, I do not want this kind of medication. The only thing the advanced
Or I
directive.
do.
Or I do.
Yeah.
Yes, and you can, I do. And I've had conversations in the past with MMC, because very few people know this, but it creates an opportunity for someone. For me, I've used the example just in terms of hospitalization or whatever, but I know what I want when I'm myself. And I know that when I'm seriously ill with depression, that is not the real me. I know that that's not the real me, and that what I want in that time is not what the real I wants. And so the ability to say, I want what I know that I really want to take place, not what I say I want when I'm when I'm seriously ill. I mean, that's a really important protection. But it is you've got to be really sure you need it.
So, I mean, I suppose,
want
yeah, I suppose that there are also, since there are two physicians required, I mean, one of them could be required to be in person at least, or both of them, or, in terms of
Determining that. you don't have
determining
capacity.
that.
Right, the capacity piece was not proposed, to be clear, it was just the witnessing and the explainer and the affirmation about the person understanding what they're doing, that
Okay, not the
people have been,
capacity piece.
not the capacity piece.
Makes me feel better.
I mean, that can be part of your conversation and we can specify, but that was not, I don't believe it was proposed.
James Santilli.
I was just gonna say, for the second time today, this is scary. I agree with Jessica about I would have concerns. I mean, of being, not for the same reason. You started to sound like me a minute ago, but, I don't know how well you can tell somebody's capacity over the internet.
Well, that's not what's being proposed.
You are saying they appear to understand.
They appear to understand what they are signing, but as far as whether they have capacity to invoke the Ulysses Clause, that is not being proposed to be done remotely.
That would be the
Okay, so I
job.
misunderstood. Okay.
Yeah, that was my question.
Okay.
Although I will say it's not specific. I mean, we do have a lot of telemedicine and it is not specific about that. So that may be something that an element you want to add in.
Yeah, Taylor.
I think what really comes up for me is it is quite difficult as I'm reading this to put a Ulysses clause into your advanced directive. You have to put it in writing, you have to name an agent, your agent has to accept it. The principal's clinician has to sign off on it as well, making sure that they understand the benefits, risks, and alternatives. And an ombudsman, mental health patient representative, licensed attorney, or probate division designee also has to sign that statement affirming that they explain the nature and effect of the provision. So I think it is not taken lightly if someone was to put this in their advanced directive in the first place. And so if all of these checkboxes are set up, I understand folks' worries about capacity once the advanced directive is in place, but that's not necessarily the question before us today. Well, the question before us today is whether we want to take this bill up. But,
Oh, that's right. Right, this is, go ahead, Ann.
So I was just going to say, I mean, one of the reasons, and a person might want to make sure that their witness, is present to get their advanced directive upheld in the court if it's challenged. That may be a separate question, but the case that's gone to the Vermont Supreme Court involves somebody who didn't want psychiatric medications. And part of the question was, did they have capacity basically to sign the advanced directive? And even though the legislation doesn't say capacity per se, it says, that appears to understand what they're signing. And that was kind of that issue, and the court sent it back for lower court review as to whether the evidence was adequate, that this person who said, yes, I witnessed them, and they understood. So there's a lot of layers to it.
Yeah. And we are going to be hearing from Cindy Bruzzese tomorrow from the Vermont Ethics Network. And she also has a great deal of information. Has been doing this for quite some time, and I should be able to answer a lot of our questions and maybe give us hopefully some data about like how often this has been used and things like that.
I don't know if we have that data. I think it's probably extremely rare because a lot of people aren't even aware of it. So.
Yeah. I mean, not only this, but also in general, like, it's the remote witnessing during the pandemic. Yeah. Yeah, go ahead, Noah.
Also, the Ulysses Clause is also just rare. I mean, so you normally, if you have one, you're anticipating a future event where you will become incapable of making a decision. That's above and beyond what the normal advanced directive is. I mean, we all eventually won't be able to make a decision. I mean, hopefully, if we all pass away. But you're living with something that is there that can cause you to become incapable of making the decision. And that's, I think, what it really is. So just the subset of people that would need a Ulysses Clause is small and in a small state.
And then the recognition that you want to do something about it, it makes
Right.
it even smaller.
Yeah, right. But Alzheimer's is a good example where if
Yeah.
you know you have the diagnosis, you're still totally capable, but you want to make sure
Right.
that your wishes are really followed and that you can't remand them.
Right, so I told Ann the story of my grandmother who got diagnosed with cancer and they wanted to put her through chemo. She was 5 years into her Alzheimer's. She was incoherent. She didn't even recognize her daughter or her husband anymore. And this prevented that from happening.
Yep. So, so we are at the stage of, making a decision about, whether we want to take this off the wall and work on it and essentially convert it to a long form bill because it's a short form bill. And we do have Cindy coming in to give us some testimony tomorrow. So I guess I just would ask committee members to be thinking about that. So when I ask the question tomorrow, you can make up your mind about whether this is something that we'd like to do. I know that there, as Jen said, there's provisions that extend to March 2024. And I think, we can ask some questions tomorrow about how often it's been used and, whether there have been any issues and things like that on that aspect of it. And then I guess we need to think more about, the, we'll ask a lot of questions about the Ulysses clause. And, but thank you for pointing out, Jen, that it's not for the physicians, it's only for the witnesses and explainers. So anybody else have any additional questions for Jen? Anybody on the screen? Doesn't look like it. No, all set? Okay. Thank you so much. Appreciate that. Yeah, it's an interesting, very interesting. I can imagine when that work was first done, how intense it was to be thinking about that in this committee. Okay, so folks, we're ending a little bit early, but we did start a little bit early, so that's good, right? Tomorrow, where is my agenda? Okay. Tomorrow is Prevention Day for Youth Prevention Day, so we'll have a bunch of folks, out on the front lawn and around in the building. Unfortunately, we don't have anybody going to give us testimony like we had here a few years ago. But hopefully they'll stop by. Lori's, mentioned to them that people were kind of nervous about sitting in front of the committee and talking and all that kind of stuff. But we said, please come in and just say hello. So we'll be nice to them, right? Of course we will. And so we see Cindy Brucese tomorrow morning, as well as also Dr. Crossman from Building Bright Futures. And we're going to see the folks from the Vermont Association for the Education of Young Children. This morning we had the National Association, and we're going to see the Vermont people first thing tomorrow, again at 8:30. Notice the start time. And so we might have a little bit of a longer lunch break, depending upon that witness on advanced directives and depending upon whether the kids decide to come up or not. And then we'll be back after the floor. We're going to be talking about and you might want to take a quick look at it. It's a quick read. It's not hard. The attendance versus enrollment report, and is on our website under reports. I thought it was very doable. It seemed doable to me. I'm looking at Ray. And then we will pick up with Allie Richards from Let's Grow Kids. She will round out our Friday. And I do not. I am gonna look at the calendar, because if floor is really short, we might put somebody else in between floor and lunch, but we won't be meeting in the afternoon.
It's Good Friday.
Okay.
I was going to say, it's Good Friday.
Well, that's only for those folks who practice that religion.
Yeah, same.
I know.
Good Friday.
Yeah.
Anybody have any, I did want to say, because I've had questions from individual members and I don't know if I've made it all the way around yet, but, so people are asking, about S18, the flavored tobacco bill and the bill on, PFAS, the manufacturers of makeup and things like that are, very interested in that bill. So, I've let people know that we have a lot of intensive work to do on childcare. I really want, since we're in the headspace of overdose prevention, I really would like us to work on the overdose prevention sites. And then I think, depending upon what we decide about this Ulysses Clause thing, I think we could move along the bill to make this, to make some of these provisions permanent relatively quickly. So that's the agenda for between now and the end. That doesn't mean that if we find ourselves, sitting around waiting for hours on end, that I might not think about having a witness or two, but we won't be acting on either of those two bills before we adjourn. So I know we're all getting emails and calls from lots of people on both of those bills. And I know it's disappointing, particularly to the folks who've been working on the tobacco legislation for many years. And I just wanted to make sure that everybody has the same information.
I was momentarily distracted. What was the other one you said we would not?
PFAS.
The chemicals.
PFAS.
Chemicals bill.
Okay. All right. Yeah, well, that just passed. So
It did.
Late. So,
It
yeah.
did. Well, and I think that just my thinking about this is, like I said, we have a lot of background on substance use and substance prevention and overdose prevention already from H222. And I thought okay, let's build on that for what we're going to do this year. And then, our mindset will switch next year and we'll be talking chemicals and tobacco and all of that. And we won't be doing, hopefully, childcare next year, because hopefully we'll be doing it and finishing it this year. So I think that just want to make sure that we were all on the same page about sort of where we're headed. Anybody have any questions about that? All right. Okay, well, now you have a little extra time this afternoon. Use it wisely, whatever that means to each of you. All righty.